actually in contrast to Graham, who had to cover such a broad number of things like functionality and limping signs and event marks even. I'm going to concentrate just on this one issue, likelihood of confusion in case of weak marks. So I do hope that I can make it short. Starting with the criteria for assessing likelihood of confusion that you all know, these are the formula that the court has set forth in its early case law. We have the similarity of goods or services, as this has been set forth in the Cannon decision. Then, of course, similarity of marks, which is assessed by comparing the visual, oral, and conceptual elements. Then the distinctive and dominant components need to be identified and compared, and the emphasis should always be on the elements that are dominant. And then we have the formula or the principle that the more distinctive the earlier mark it is, the greater will be the likelihood of confusion. And distinctiveness in that sense can result from two different things. Either the mark can be distinctive per se, because they are very fanciful and not suggestive, in order to use these terms that are from American terminology, or because they have gained some reputation or some goodwill on the market. And then in the end, there needs to be this final step of judging the likelihood of confusion from the overall impression that the marks create, and this must be done from the perspective of an average consumer. So we know all that. I'm going to concentrate, as I said, on this one, namely the influence of distinctiveness, or rather the influence of lacking distinctiveness or of weakness. When we're starting from the basic principles that were set forth in the court's jurisprudence, then we can easily conclude that the likelihood of the likelihood for finding a likelihood of confusion, or the probability of finding likelihood of confusion, is very high if the marks are similar in features that are very distinctive, and that are also dominating the impression of the mark. Very often, of course, this goes together. If there is an element which is very distinctive, which catches the eye, then it will also normally be dominating, but both assessments, or both types of assessments, need to be separated. Vice versa, this is just the inverse conclusion. Likelihood of confusion is less probable if the common elements are weak and are just barely passing the threshold of finding distinctiveness. And then the third conclusion one could draw is that if even a minimal degree of distinctiveness is lacking, or if an element which is common to both signs that we need to compare in order to find likelihood of confusion is straightforwardly descriptive, then this should exclude a finding of likelihood of confusion. This is not something that we can find in the written law, at least not in the statements that were quoted on the first slide, but it seems to be a result of logic, of systemic logic applied to what was said before. Because after all, if marks are not distinctive, and also definitely if they are descriptive, then we know that there is a need to keep those elements free. That has been spelled out expressly with regard to descriptive marks or descriptive signs, and it's certainly also true to some extent for marks that are simply found indistinctive. So these are elements, or these are marks that should be free for others to use, also for their commercial purposes. Now, if these elements form part simply of a more complex sign, then of course the interest of keeping those elements free doesn't go away. It's still there. And out of that sort of thinking, it appears to emanate as a matter of self-evidence, nearly, that if we only have a coincidence between two signs that concerns those elements that need to be kept from protection, that need to be kept free from protection, this should also not corroborate, this should also not allow a finding of conflict between the two, with the result, the obvious result that then one of the signs gets an exclusive position vis-à-vis the other. Okay, if we have come so far in extrapolating certain principles from what we have seen in the statements of the court, then we have to compare this with the jurisprudence of the General Court and the Court of Justice. Now, basically, of course, at least the two first of the conclusions that were drawn on the previous slide, they are actually confirmed. Indeed, also in the case law of the courts, you find that if there is only coincidence of very weak elements, then it is less likely that likelihood of confusion is actually found. However, both courts very clearly refuse to accept that the interest in keeping a sign free from monopolization, from exclusive rights, that is basically underlying the assessment that elements are descriptive or are indistinctive, should play a decisive role for the measuring of likelihood of confusion. Instead of accepting that sort of at least the third sentence that we have seen, and also the fact that both courts treat those conclusions, even in the first two cases, as something which conforms with or which can be a regular feature of assessment, which is definitely not a stable and reliable rule. For that reluctance of the court to accept that, two reasons are given. First of all, it is pointed out that, after all, the assessment of the degree of distinctiveness, and that includes, of course, also the assessment of whether features are descriptive, is just one element of a very complex exercise. So it should not be sufficient to rule out findings that have been made on the basis of looking into the other elements. It cannot rule out a finding of similarity that has been found with regard to the visual, oral, and conceptual elements. And also, it is said by the court that the distinctiveness of marks does not necessarily influence the perception of consumers. Of course, normally there is a correlation between the perception of consumers and the distinctiveness. It is the essence of distinctiveness or of lacking distinctiveness that consumers don't realize or don't perceive a sign or an element as conveying a message about commercial origin. They just see it as an element of a product, a decorative feature, or something which is in the background and which has no meaning in terms of indicating commercial origin. On the other hand, the court refuses to take this as something which is which needs to be taken for granted. So even if a feature is indistinctive or if it is descriptive, it does not necessarily, in the view of the court, translate into the consumers not viewing this, when it appears in the context of other elements, as making the mark indistinctive, or at least something, or taking away the impression that was created by the overall similarity that is based on other factors. So how does this then play out? I gave you in the following a couple of examples. This has started earlier, and I'll give you other references to cases, but I chose this as an example to consider the effects of the court's jurisprudence. So this was for products that were largely similar. So one was key equipment, the other was backpacks, etc. But both were, well, basically, if you could, they were registered in the same classes, or were meant to be registered in the same classes, and they were both largely for outdoor products. So not necessarily identical products, but very similar products. Then the two marks, figurative marks, one are Alpine Pro, with a Pro, of course, in this, the actual display of the mark and the actual appearance of the mark appearing rather small, and the other one Alpine, both figurative marks that have as their dominating element the word Alpine. Now, Alpine arguably is descriptive or is near descriptive for the products for which the marks were to be used, because they referred to the region where these goods are usually used, worn. Especially, that's of course especially true for the skiing gear, the skiing equipment, but also the backpacks are goods that are very closely connected with outdoor activity that one can do in the Alps. So descriptive or near descriptive words. This was the argument made by the applicant. The applicant said, well, look, these marks are quite different when it comes to the figurative elements. We also have this different element of prose, so there are sufficient elements to distinguish them. Of course, there are similarities, but these similarities rest primarily in the word Alpine, and that word is descriptive, or is at least near descriptive. This argument was rejected by the, well, already at the at OHIM, or the EU IPO, and then also at the General Court. And the General Court's reasoning was finally confirmed by the Court of Justice. The Court of Justice were brought forward the arguments that were already developed in previous case law, namely the arguments that I mentioned before, that the distinctiveness of the mark is only one element in an overall assessment, and that it does not have a direct impact on the perception of the consumers. And that and then as an additional argument, they said, okay, we really have to come to this conclusion, because if we would come to a different conclusion, namely that the very weak character of the word takes away, or is sufficient to find that there is no likelihood of confusion, then we would be in a very difficult situation in case that the other elements as well of a compound mark are extremely weak, so that they don't give any additional elements for distinguishing the mark, because then in that situation the earlier mark would only be protected against a one-to-one reproduction, and that is something that we can't accept. I'm not sure whether I can consent to that. I would assume that why not? I mean, if I choose a mark which is very weak, and if I just choose additional elements, making it a limping mark, or not a limping mark, but choosing fig leaves, which are not really fig leaves, but which are sort of transparent as well, then of course what I get is a protection which is extremely narrow. Why not? So I don't understand this reluctance of the court, or the reservations that the court has against, in certain cases, cutting down the protection which is granted to a very weak sign to a mere reproduction. So here you see a number of other cases where, well, the same sort of argument is simply reiterated by the court. As you know, the court very often proceeds by some sort of cut and paste technique, and the phrases that I have pointed you to about the distinctiveness of marks just being one element in the overall assessment, etc., they appear in a lot of other cases as well. I show you here pictures of one of the cases where I find this has been really taken to extremes, this finding of likelihood of confusion between marks which are, well, on the one hand, not really very similar in my view, and then if similarity is found, the similarity is really only in a motive which is very descriptive on top of it of the products for which it stands. So this is for olive oil, for two different brands of olive oil. So you see that the products are, or that the mark consists of a word element, which is definitely different. Then, of course, there is a picture, but the picture is also different. It's just coinciding in the elements that we have a woman sitting under an olive tree in a southern landscape. And that is something which is arguably quite descriptive of the kind of product that we see here. So we come here very close to something which is a mere protection of a motive, of a visual motive, a woman sitting beneath an olive tree in a southern landscape, which on top of that is also descriptive. Here's one thing from the case law of the General Court. Also, no surprises here. It's really just to show that this is not the cases that I've pointed to. They are not outliers. They are not exceptional cases where the court got it wrong or got it in a way which is arguable in one or the other way. There is a certain pattern here, and when talking with practitioners who also feel that they share this concern. I mean, very often I have to admit that we as academics, we are concerned about things which in practice really have no big impact. But this one here seems to be something of real concern. Now, this is one decision by the General Court, Star Snacks and Star Foods, both for foodstuff, as one can imagine. So the coincidence was in the word star, and star, according to, I think, standing practice of OHIM, is taken as denoting superior quality. So it is descriptive or near descriptive. Nevertheless, the General Court, applying all the criteria, found a weak degree, visual similarity, quite obviously, because there is just, this is just, one is figurative, one is a word mark. Then a certain degree of oral similarity, yeah, sure, because both have the word star, and a high degree of conceptual similarity. Now, I find that a little bit ironic, because the high degree of conceptual similarity comes out of the fact that both, of course, use this descriptive thing. So conceptual similarity here is used as an instrument to reinforce the protection which is granted for completely, or at least near, descriptive science, which is, I guess, not the real purpose of taking a conceptual similarity on board. If the concept is a descriptive concept, then the fact that both coincide with regard to that descriptive concept should not add to finding of similarity. Okay. We have a particular problem when we have conflicts with marks that are descriptive but have been registered in a member state, because in that case, in proceedings before the office and also before the General Court, etc., it's not possible to adjudicate on the validity of those marks. So basically, it's not possible to say, okay, we consider the mark for our decision as indistinctive or as plainly descriptive. There always needs to be attributed at least a modicum of distinctiveness to signs which are, after all, validly registered. Of course, this is something that needs to be assessed on a case-by-case basis. I don't have it on the slides here, but there is a decision by the General Court dealing with the word post. For postal services, it is registered in Germany based on acquired distinctiveness. and it was invoked as a ground for opposition against, I think, TPG Post, when they applied for a community trademark. In that case, it was found that although the word element post was actually comprised identically or was contained identically in the application, still there was no likelihood of confusion because in the context of the acronym which was used in addition to a post, the word post became a completely different character. It got a completely different character in the perception of consumers. So this is not a rule which applies automatically in the same way all the time, but is something which needs to be taken into account. This, again, the practice of the courts with regard to weak marks seems to be something which is which is a pattern, which is not just found in exceptional cases, and it actually clashes, or it is incompatible, or it's different from practice which has been developed in at least certain member states. For instance, in Germany, there is standing practice of the court that if there is just a coincidence of indistinctive elements of a compound sign, then no likelihood of confusion can be found. And also in some of the boards of appeal at the office, this practice seems to be taken up. I have been, I refer you here to the decision phone. This was, phone was registered as a word mark in the UK, which I find amazing because after all, for telecommunication services, so there are also sometimes things that escape the attention of the practitioners, but it was also registered as a figurative mark in the EU, and then there was, they opposed the application for N phone, and here the Board of Appeal said, well, phone basically is completely descriptive, so, and the coincidence of the sign is just in this element phone, so there cannot be, we cannot possibly base the finding of likelihood of confusion on that coincidence. Unfortunately, however, so this is how the Office and the Board of Appeal react, at least some of them, but unfortunately also in this case the end result was what we have seen before. The General Court and the Court of Justice found that there is a likelihood of confusion, given that phone, after all, is the dominating element in the mark. The fact that there is a certain discrepancy in practice has resulted in the issue being taken up in the convergence program, and well, there has been finding. Well, of course, in the framework of the convergence program, it is not possible to overrule the Court of Justice and the General Court. That's for sure. But at least some steps were taken to say that if an element is indistinctive or descriptive, it should at least not be considered as dominant, which would help to some extent. But again, the Court of Justice and the General Court are not bound to that, and obviously until now they have not really reacted. So I tried to formulate my critique, but this is, I think, has become clear already from what I said before. I really think it's one of the major flaws in the Court of Justice's case law, that they seem to think that aspects that have to do with competition, and I agree that it's very difficult to talk about competitive elements in the context of trademark law, but competitive concerns are there. And the Court of Justice seems to think that if they are taken into account, first of all, in the registration stage, when it is about application of Article 7, first paragraph, small c, that is if the examination has been dealing with descriptiveness and no descriptiveness was found of the entire sign, or then the deal is done and we don't have to look into this anymore. And they are completely wrong about that, because competitive elements can play a role in all stages of the assessment of trademark conflicts. It's not gone, it is there. We are talking about something which plays out in market reality, and in market reality it's both, it's the consumers, it's of course the interest of the trademark holder, but it's also the competitors' concerns that need to be taken into account. Once one of these three elements is simply neglected, the courts and authorities get it wrong, and the Court of Justice unfortunately does get it wrong in this regard. And as Graham has already said, there are indeed certain normative elements that need to be taken into account. It's not just about consumer perception, and consumer perception itself is something which is sometimes filtered through normative elements. Okay, so we, of course, now I've come back to the trademark study that we did in the Max Planck Institute. We actually tried to make the courts and authorities aware of this problem, having been alerted to this through previous practice, and point out in the preamble that it should not be possible that likelihood of confusion is found if it is only based on indistinctive or descriptive elements of a sign. We also did this, I have to add this, because we also proposed to delete mandatory disclaimers and in order to alleviate concerns that this would allow too many signs having indistinctive elements into the register. We thought it would be a good idea to make it very clear in the preamble that one should be cautious about finding likelihood of confusion. This was unfortunately not adopted. Well, we have discussed it a little bit also with Mr. Eichenberg. I mean, the countries, the member states themselves, they didn't want the preamble to be too heavy, so one can really discuss what can be put into the preamble and what not. In any case, it's not there, so we have to live with the situation as it is now. One little sign of hope, or one little element that I want to highlight at the end is, however, that there may be some relief coming from the new formulation of the limitations and exceptions, because, as you may have noticed, the second indent in that provision, the small b, has been complemented by pointing to signs which are indistinctive. Until now, we only had the possibility to use signs for descriptive purposes, or signs that are descriptive, to point out the properties of one's own or product or that of a competitor. Now it's also possible to use a sign which is indistinctive, as long as that is is compatible with the honest business practices. And that could at least help to ease the situation in case of the limping signs. So if well, yeah, for instance, the golden bunny, if I may take this example, I don't want to hurt anyone's feeling. I don't know whether somebody is here in the room representing Lindert Sprüngli, but let's take that example. If the golden bunny shape with the red bow and the bell, golden wrapper, is registered as a 3D shape mark because of the distinctive element that it has, namely the words Lindert Sprüngli written on the flanks, then they can, or they can, of course, try to raise claims for infringement against somebody who just has a similar shape on the market without using the mark. But then this person, on the basis of the new limitation, would arguably be able to say, okay, but my shape is indistinctive because the shape of a bunny as such is not distinctive. So I'm still able to use this. Again, under the control of this final assessment of whether it is compatible with honest practices. So it can help in case of limping signs. The other question is then, and that I can't really answer, I can just hope that it may raise some awareness. The other question would be whether the legal principle which underpins this change, namely that fair use of indistinctive or descriptive elements should not be prohibited, is something which will also be taken into account in the future case law of the General Court and the Court of Justice. And this is what I wanted to say. Thank you very much.